Hey everybody, Attorney Bill Harrington here. Today we are going to be talking about probate and estate administration. This is what happens after you pass away. So we're going to be turning things over to Sarah in our Palmetto division down there in beautiful South Carolina. Sarah, you got some questions. Go for it.
I do have some questions. Do I have to open an estate if someone dies?
Not necessarily. Depends on a number of factors. Most importantly is how things are titled. So by way of example, a husband and wife usually own most of their stuff as tenants by the entireties, which is just a fancy legal term of how husbands and wives own things. And the law is that when one spouse passes away, the other spouse becomes the full 100% owner of that property automatically by operation of law. You don't really need to do anything. So if, heaven forbid, your husband passes away, your wife passes away, and you have all of your major property owned as tenants by the entireties, owned in that complete way, you're probably not going to need to open up an estate because there's no need to. Everything is going to become yours by operation of law, and assuming that's what your will says. If your will says, "Oh, I have a vacation home, I'm going to leave it to my nephew," maybe then an estate might be open. But in that husband and wife situation, it likely won't be. If there is property, though, and I just mentioned it with the vacation house, if there is property that is owned singularly by the deceased person or is going to somebody else that is not in ownership, then you need to open up an estate.
What's the difference between probate and estate administration?
So they're really two different terms for different parts of a much broader process that from a 30,000-foot view, we call estate administration. So the probate process is just the process by which either the executor, the nominated executor in a will, is given letters testamentary, or an administrator, if there's not a will, who volunteers basically to do it, goes in and petitions the court to get letters of administration. I will go over the difference between intestacy and having a will a little bit later on, but that's basically what's considered the probate process. You file a petition, you go into the register of wills in the county that the decedent lived in when they passed away. So let's say it's here in Lancaster County. You go into the Lancaster County register of wills, and executor or the administrator swears an oath that they're going to abide by the statute or the will or what have you. You pay a fee, and then that kicks it off. At that point, you are now granted by the orphans court power to access the property of the decedent. And if you show what are called short certificates to a bank or a realtor, you now have the power to access those funds, transact business, and sell real estate if that's what is needed. Estate administration is really, in my view, the entire process, and it starts with probate and ends with the release and the final status report. And that is more of the technical details. So marketing real estate, selling real estate, accessing bank accounts, making the distribution to beneficiaries, publishing the estate to notify creditors that they have a year to file their claims, notifying all potential beneficiaries. There's a lot of things that need to be done in this whole process. And as a whole, from a 30,000-foot view, we call that estate administration.
How do I start the process?
So first thing, hire an attorney. Second thing is you'll want to file that petition. So first of all, you have to figure out if there was a will or if there was not a will. Okay, because that's going to determine what you're actually petitioning the court to give you. If there was a will, you are going to petition the court for the grant of letters testamentary. So another one of those fancy legal terms that it sounds a little bit dated, but basically you're asking the court, the orphans court specifically, to give you, the executor, the power to handle the estate, to transact business, to distribute properties, sell it, what have you. So there is a petition, fairly simple. I do it for my clients all the time. You complete that, and then you go to the Register of Wills. Register of Wills will look at the petition. They'll look at the will. They'll look at your photo ID. They'll also want the death certificate just to make sure the decedent is, dead. And then, of course, there's a filing fee. Now, that filing fee is based on the estimated amount, estimated value of the estate. So you go in and they make sure that all the ducks are in a row, and then you swear an oath. And we mentioned this earlier. You swear an oath that you are going to follow it, faithfully execute the terms of the will and administer the estate as per the statute. You do that, you pay the fee, and then that's really it. You're off to the races. A few days later, they'll give you what are called short certificates or short certs. And basically think of these as like a Reader's Digest version of the actual letters testamentary. These are more portable. They're usually about 1 page or about this big. It's not even a full piece of paper. You take this to banks, real estate offices, investment houses, any place where you need to access the assets of the decedent. They're going to want to know that you have the power to do that, because otherwise I can't go and sell your house. Only you can do that. But if I show that you passed away and that I'm now the executor, I can now do that. And that's basically, those short certs act as proof of that. Contrast that with letters of administration. And again, we'll talk about this a little bit more detail later, but letters of administration is when there is not a will and some person, usually, one of a few that are eligible, raises their hands, says, I will do it. The ones that don't want to do it, they complete what are called renunciations, meaning they're giving up their right to be the administrator of the estate. And then it's really the same kind of process. You file the petition, you go in, you have your photo ID, you have the certificate of the death certificate, you swear that there was no will, you describe your relationship to the decedent, you hand in your renunciations from anybody else who may have been eligible to be an administrator, and then you swear that oath, pay the filing fee, get short certs for the letters of administration. And then at that point, you have the same power as an executor would.
What happens if there is no will?
Well, that's called intestacy. In fact, we were just talking about that. If there is no will, the estate, you were considered intestate, meaning without a will. And then what will happen is when you file your petition, or your administrator will be given letters of administration. Again, they give the same powers as letters testamentary. They're just called something different because we have to be difficult. We're lawyers. The distribution of property is really where some of the major differences between having a will and not having a will come in. If you have a will, the property is distributed under the terms of the will, and that's it. And Pennsylvania law is pretty clear that wills are inviolate, meaning they cannot easily be challenged, except for this is a fraud or the like. They're honored by the courts with great prejudice. When it comes to intestacy, distribution of property is governed by statute, and there are formulas depending on who the decedent was, who has survived the decedent, that then determine who essentially gets what. So, by way of example, if you pass away and you have a surviving spouse and you don't have any children, surviving spouse gets everything. If you do have children, the surviving spouse gets the first $30,000 of your estate, and then half of whatever is left over. Okay, and then the other half of whatever is left over gets divided equally among the kiddos, the issue, as they're called. I don't know why they just call them that. But there could also be children, grandchildren, etc. If you don't have a surviving spouse and no kids, but let's say your parents are still around, then it sort of branches out to parents, siblings, even aunts, uncles, nieces, nephews. I mean, it go pretty far out from who you are in how closely related these people are. Most of these states that I've handled, it either goes to a surviving spouse, or if there is no surviving spouse, then to the kids, or some combination of those two. But again, it's all governed by statute, so you can't just get in there and wing it. Say, hey, I want everything. You have to follow that statutory formula.
How long do I have to file after someone passes away?
Well, there really is no set time period by which you have to file or open an estate. I've seen estates that, for whatever reason, they weren't ever open. A few years later, someone else passes away, and now we kind of have to go back a few people to bring everything current. And it can be done, but it's kind of a pain in the neck for you as an executor, and also for your attorney. Hint. There are, however, certain deadlines that are baked into the statute. So, by way of example, the inheritance tax return that needs to be filed within 9 months of date of passing, and if there was any inheritance tax owed, or would have been any inheritance tax owed, you need to pay that by that 9-month mark, or you start generating interest on whatever the taxable amount is. So that is a separate deadline that operates independently of whether or not an estate has been raised.
What debts have to be paid?
If the estate is solvent, all of them. It's sadly enough, and I've had that conversation with people say, hey, sorry, there's this $5,000 credit card, or there's a medical bill, or what have you. That needs to be paid. Now, there is a hierarchy, a pecking order, that the order of which you pay certain creditors of the estate. Your funeral home is near the top, or at the top of the list. Attorney's fees, last medical bills for your last illness, or what have you, the illness that may have led to your passing. And then further on down the line, credit card debt is fairly low on that particular list. If the estate is solvent, meaning it can cover all that and still have enough for beneficiaries, then great. You have to pay those, presuming that everybody files a claim against the estate. And that is why you publish the estate in the county legal journal and a newspaper of general circulation. You do that, and then that puts creditors on notice that, hey, you have a year to file this claim, or you forever lose your right to that, to collect on this from the estate. Usually, they monitor that kind of thing, and if there is a real claim out there, you'll start, as the executor or the attorney, you'll start getting bills in the mail, or claims in the mail saying, hey, so and so owed us $2,000. If they don't file a claim, then take a hike. See you later. That's for solvent states, where they have properly the creditor has properly filed a claim. For insolvent estates, and this does happen, unfortunately, where the debts of the estate outweigh the actual estate value, then again, that pecking order does come into play. And when the money runs out, it runs out. And not only can that mean creditors who are a little further down in priority, but it can also mean beneficiaries. It's certainly possible for there to be so much debt in an estate that at the end of the day, there's just not any money left over for the beneficiaries, and they don't get any inheritance. It's sad, but as an attorney, you have to manage the expectations and put that on the radar, because you don't want any nasty surprises coming on at the last minute.
Am I personally liable for their debts?
No, you're not. An executor or an administrator is not personally liable for the debts of the decedent. So if that were the case, I'm not sure anybody would jump up and be an executor or an administrator or anything like that. What you do have to be careful of, though, is making sure that you've paid all the valid claims that come in, making sure everybody, all the creditors against the estate have been taken care of before you make the distribution. If you make a distribution without having done that, it's called a distribution at risk. And essentially what that means is, if you as the executor just distribute everything to the beneficiaries and empty out the estate account of all the assets, A creditor who files a valid claim thereafter can say, well, wait a minute, you gave all the money to the beneficiaries. We need our money. And at that point, the executor or the administrator could be held personally liable. So that's why they use the word at risk, because there is a risk. So what I would always advise is, if in fact that you want to make that distribution, make real sure that there's not some creditor cockroach in the woodwork that's going to come after you, and that you didn't know about. Make real sure that you know the entire financial picture of the estate, and then also when you make the distribution, have something in writing that provides for a clawback. Meaning, if there is a creditor that was not anticipated and they do file a valid claim, that all the beneficiaries who got that distribution at risk agree, okay, we're going to put our part of our inheritance back to the executor to pay off this creditor.
Do I need an attorney to administer an estate?
You don't technically, and a lot of people you go about it pro se. And on the upside, if you decide to handle an estate on your own, the Register of Wills, it depends on the county, obviously, but they'll have some pretty good resources for you to help guide you through that process. And maybe I'm a little biased, it's a lot easier if you have an attorney, because there are things that need to be done by certain times. Otherwise, you could potentially have a creditor that wasn't given notice, that 2-3 years down the road, they come after the estate. There's a lot of things, a lot of moving parts, particularly in the beginning of the estate administration process, that it really helps to have an attorney who's done this and knows the ropes. What I try to do for my estate administration clients is pretty much everything that they wouldn't be able to do themselves. So I publish the estate. I send out the notices of beneficial interest. I draft the petition. I get the petition filed. I accompany them to the Register of Wills, just in case there's a last minute question. I can address it right then and there, or you find out what needs to be done to complete the initial probate process, the opening, the raising of the estate. I'll draft the inheritance tax return. I'll calculate the initial amount of inheritance tax, and if you make an estimated payment of that tax within 90 days, you get a 5% discount at the end. So you need to know to do that. Really, the only thing that I ask of the of the administrator or the executor, my client, is that they handle the inventory of the estate, meaning just going through and figuring out what the assets are and how much they're worth, and then retaining a realtor to market real estate. I will usually attend the closing. Again, if in case any last minute questions come up from a legal standpoint, I can be there to address them. Usually in the way of how the chain of title of the real estate. If there's anything missing, I can address it. But the actual marketing of the property, I usually put that in the hands of the executor, simply because it's easier for them to do the inventory and market the real estate than it would be for me to do that. So that's the long answer. Short answer is you don't need one, but you really need one.
How long does the process take?
There's a lot of variance there, but it can take a while. Again, once you publish the estate, the creditors have a year to file a claim. Technically speaking, the estate can be open for at least that amount of time. Usually they end up being anywhere between a year and 18 months. It's really not a quick process. And this is something that I've had clients ask me about. We're in month 2, 3, 4, and they're wondering what the status is, thinking it's a much shorter process than it actually is. Just by way of example, the Register of Wills, the Orphans Court, they don't even want to hear about an inventory being filed until 4 months after date of passing. You can't file it beforehand, before that 4-month time period. So really at least 4 months, but most of the time a lot longer. So it's important to know as an executor, as an administrator, that this isn't going to be, you hire me on Monday and you get your inheritance on Friday, or even next Friday, or even next month Friday. It's going to be longer. It's going to be longer than that. There are things you can do to accelerate it. You can get the notices of beneficial interest out, the publication out. You can estimate your inheritance tax and make that prepayment. There's a lot of things you can do to move things along. But let's say there's a house involved. Well, who knows when what the housing market is going to be like at that particular time? Very few people plan their death around spikes in the housing market. So it could be just a dead time for housing, and there you are having to market a property because it's an asset of the estate, and you need to liquidate it. If that's the agreement, you liquidate it and then pass the proceeds on to the beneficiaries. So let's say that takes 5 or 6 months to do, and it's no one's dragging their feet. It's just the house isn't selling, the market's not hot. That can add to the process. Usually, cash money in bank accounts that are already liquid. That's pretty easy to do. You can go once you get your letters. You get your EIN number, which is basically a social security number for the estate. You get that. You go to the bank, hand them the EIN, hand them the short certificates, and then you open up an estate account that is essentially the estate's bank account. All the liquid money, all the proceeds from any sales goes into that account, and that's where you make your distribution from. That can be done fairly quickly, but again, between the creditors having a whole heck of a lot of time, between the inventory, not even being wanted before 4 months, and some of the volatility in real estate markets, et cetera, it can drag. It can drag a little bit. So it's important to know that before you go in and set those expectations pretty early.
How are the taxes handled?
So Pennsylvania was one of just a handful of jurisdictions that still has an inheritance tax. And the way those are calculated depends on who you are in relation to the decedent. Okay. So if you are the surviving spouse, your tax rate is 0. It's 0%. You're not going to owe any tax on it. If you're a child or issue of the decedent, then your tax rate is 4.5%. A little bit further out, I believe his parents, a few other, types of family members, you're talking about a 12% tax. And then pretty much anybody else, nephews, cousins, or, just some rando on the street that you wanted to give money to, that gets taxed at 15%. Now, what you can do, and this is one of the reasons that I handle the inheritance tax, is kind of like your income tax. You can take deductions from the total gross estate and get a net taxable estate. So the deductions you can take are your funeral costs, and they can be $10,000 more depending your funeral cost, your reception, things like that. If you've hired an attorney, the attorney's fees will be deductible from the estate. If there are any debts of the decedent, say a mortgage, credit cards, medical bills, those are deducted. So you have all of these deductions that you can take advantage of, and then that reduces the amount of money that you get taxed on. 4.5%, doesn't sound like a lot, but if you're dealing with an estate that has a decent amount of assets, it can add up. And so you want to make sure that you save your client as much as you possibly can.
I believe we touched on this, but what if the estate doesn't have enough money?
Well, we did touch on that, and that's called insolvency. So if your estate has more debts than it has assets, and it unfortunately it does happen, then the estate is considered insolvent. And in those situations, there's that pecking order of creditors, starting with your funeral home and your medical bills, your attorney's fees, etc., all the way on down to some credit card you might have. And when everybody has eaten up all the assets, then whoever hasn't been fed yet, they go hungry, and that can be creditors, and it could be beneficiaries.
Can beneficiaries fight the will?
They can. Fortunately, and I should knock on wood, I haven't had a serious, will contest, in any one of my administrations. But yeah, they can fight the will, and usually the grounds for fighting the will are if there was some kind of undue influence, meaning somebody coerced the decedent when they were still alive, obviously, to change their will in someone else's favor, in that person's favor. That's really really hard to prove in Pennsylvania. Again, and we mentioned this earlier. The words of a will of the testator. That's who a testator is, who has written the will. They're almost sacrosanct, and courts are very very reluctant to look past the explicit words of the testator and order some other distribution to be made. If there's some kind of undue influence there, again, that's a really high bar. There's a test that you have to go through. Was there some sort of confidential relationship? Was there a huge imbalance of power? Certain other elements that the contester would have to show to essentially say, look, the testator, when they rewrote the will, was not actually doing so of their own volition, and the courts will take that into consideration. Another way that a will can be contested is if there is inadequate execution. Let's say the will wasn't signed or wasn't witnessed, or there's a suspicion of this wasn't really this person's signature. Those can be grounds for a will contest as well. I have seen provisions that essentially says if anybody contests this will, then their inheritance is cut off. Basically, that beneficiary is treated as if they had died before the testator and didn't have any children. So basically, it just all goes back in and gets the assets get distributed back to the main estate and the remaining non-contesting beneficiaries.
What if there's property in another state?
Yeah, and I've had this happen to me. We had a place. My guys were here in PA, and there was some real estate in Delaware. What you need to do is you need to open up what's called an ancillary estate. The powers of Pennsylvania and the Orphans Court of Pennsylvania, they don't cross state lines. So the Pennsylvania court would have no authority to permit somebody to be able to handle and transact business in Delaware. What you would need to do is you would need to contact the Delaware, the county in Delaware or Maryland or wherever it happens to be, their register of wills, wherever the real estate is located. So let's just say it's Newcastle County. You would contact the Newcastle County Register of Wills, or whatever they call them down there, and you would need to open up an ancillary estate. If you wanted an attorney's help to do that, you would need to contact an attorney licensed in that state.
Can I get paid for being an executor?
Yeah, you can, and a lot of times people do opt for that. Sometimes they decide, no, I'll just put it into the rest. But an executor and administrator is entitled to what's called reasonable compensation for their efforts. And what's reasonable really depends on how complicated the estate was to manage. If it's fairly simple, you're probably not going to get away with charging 33% of the estate value. That's going to be a little bit much. In fact, the good rule of thumb is to keep that in the single digits, at least in my view. But if you have an estate that is just a nightmare, then yeah, you could justify a higher executor fee or an administrator's fee. A story that I have, it wasn't me or any estate that I handled, but I knew of someone who was named the executor in a will, and it was as a cousin, a little more distant family member, and unbeknownst to them, the decedent was a hoarder. So she owned a house, and they walk in there, and it's floor to ceiling stuff, just jammed in every possible crevice. And what they were finding is that tucked away in some of these files were bonds cash money, loose cash money. A lot of older people still have, that on hand. And it was it was almost 2 years, I think, that this estate took to be administered, maybe even longer. And they were there almost every weekend, just cleaning the stuff out, hiring, those big junk dumpsters, and just putting everything that didn't have any value in there, donating other things, and trying to take some kind of an inventory of exactly what was all in this estate. So at the end of the day, that executor, they said essentially, yeah, you're paying me for this one.
What happens if we do nothing?
Uh, well, it can cause problems later on, especially if there's the need for an estate to be opened, meaning there's property of the decedent that's not co-owned by anybody, by the entireties, or the will wanted gave something to somebody else who wasn't on title. If you do nothing, it can create some issues you later on. So just by way of example, if you say, I'm going to leave my house to my kids, and they're not on title, and you pass away, you don't open an estate, it's still going to be in the decedent's name. The deed is still going to be in the decedent's name. Now, let's say one of the kids, have been living there for 20 years. And then they write a will, and then they say, "Oh, I want my house at such and such address to go to my children." That's going to be a problem, because technically speaking, that home was not that child's to give via a will. So you'd almost need to go back in time and try to wrap that up and bring it forward. And you just hope that everybody's on board with that and doesn't decide, "Oh, well, no, wait a minute. If you don't own the house, can't give it to the kid. It's got to be, handled some other way." Maybe even a partial intestacy, meaning there's no provision for the house, and in a will, at least that's valid. And now you have to go and do something different under the intestacy statutes. So it can really cause a lot of issues later on. So it's important, and I've seen it happen. People come to me, and the estate for somebody hasn't been never been opened, and there's a question on title and things of that nature. It can be handled, it can be fixed, but it is not the easiest thing in the world to do. It's going to add a lot to your costs, a lot to the time that it takes to administer these things. So the best bet is to just get it done. And if it seems like an overwhelming and intimidating process, you're not wrong. But that's why I'm here. I definitely offer free consultations. It just makes the most sense. I want people to be able to feel comfortable sitting down and going over all of the details of their case without having to worry if they're on the clock or if the meter's running or anything like that. You can get a hold of me by phone, 484-459-5075, through my website, wphlawoffices.com, or email, which is bill@wphlawoffices.com.